Hello, everyone. Thank you for joining us and welcome to our online event titled Pushbacks at European Borders, From Evidence to Action. My name is Stephanie Pope. I work for the NGO Refugee Rights Europe, and I will be moderating our discussion. Today's event is co-hosted by Human Rights Watch, Refugee Rights Europe, and the End Pushbacks Partnership, which is a collective of 10 independent grassroots groups and NGOs working across Europe to collect evidence of pushbacks and other forms of border violence, while also supporting individuals on the move through service provision or advocacy. The partnership is also a co-publisher of our new Europe-wide report on pushbacks that my colleague Barbara will introduce shortly. Today we have brought together various stakeholders from civil society and NGOs to EU and Council of Europe institutions and agencies, working closely on the issue of pushbacks and European border and migration policies more generally. We've come together at quite a crucial time, shortly after the EU Commission has published its proposals on what a future EU asylum and migration system might look like, and which EU member states' governments, members of the EU Parliament, and other stakeholders are now negotiating. This is taking place against a backdrop where over the past few years, illegal pushbacks have emerged as what one could describe as a Europe-wide approach to migration governance. Simultaneously, pushbacks can be considered a symptom of failed EU migration policies, not least the Dublin system. Characterized by an ongoing sense of impunity and lack of accountability, pushbacks lead to an erosion of trust between EU member states, as well as between member states and EU institutions, and therefore go to the heart of central challenges underlying the project of a shared EU asylum and migration system. Over the past 6 months, there has been a growing and welcome recognition thereof, not least through EU Commissioner for Home Affairs Ylva Johansson's public assertions of the need to effectively monitor and investigate these practices, a recognition that we also see reflected in the new pact to an extent. In recent weeks, the issue has again come to the forefront of media and public attention due to developments in the Mediterranean, as well as at Greek and Croatian borders, to name a few. These events have not only highlighted the immense human suffering caused by these practices, but have again thrown into sharp focus the roles and responsibilities of EU institutions and agencies, whether in indirectly contributing to or knowingly tolerating pushbacks, or in holding perpetrators accountable within their respective mandates. In today's discussion, we will therefore examine these recent developments on the ground and in the policy sphere and explore ways forward in policy, law, and practice to end pushbacks and hold perpetrators accountable. A few technical points before we hand over to our first panelist. Our discussion is structured into 3 sections. The first examines Europe-wide evidence of pushbacks with examples from specific locations, as well as EU institutional obstacles in holding perpetrators accountable. The second panel highlights civil society's work in documenting and investigating pushbacks, as well as the civil society response to the proposed border monitoring mechanism in the new pact. And finally, in panel 3, we will focus on reflections and responses from EU institutions and agencies, as well as the Council of Europe, on potential ways forward. Each section will be followed by a 15-minute Q&A, so please do send your questions through the Q&A function at the bottom of your screens throughout the panels, indicating clearly which speaker they are addressed to. We will be receiving them and reading them out, addressing the relevant speaker one by one following the panels. Today's event will also be recorded, and you will receive the recording after the event, along with key resources that will be discussed today. And finally, a note to all panelists to please mute yourselves unless you are speaking, and a gentle reminder that I will jump in to alert you if your speaking time has elapsed, to ensure we have enough time for Q&As. With that said, let's move right on to the first panel on examining the evidence of pushbacks in Europe and institutional obstacles to accountability. Our first speaker is Eva Kos, who is Western Europe researcher at Human Rights Watch, based in Athens, and who will be outlining Human Rights Watch's latest work on pushbacks in Greece and Cyprus. Eva, the floor is yours.
Thank you, Stephanie, and a big thank you to all our participants for being here today. So I started working with the organization more than 10 years ago. And one of the very first Human Rights Watch reports on Greece I came across was from 2008. It was documenting a systematic pattern of brutal Greek police pushbacks of migrants and asylum seekers at the Evros River that divides Greece and Turkey in northern Greece. And sadly, it was not the last time I saw such abuses taking place in Greece. For years, asylum seekers have told us that Greek security forces and often unidentified armed men who are masked conducted illegal pushbacks at Greece's land and sea borders with Turkey with total impunity. So we reported on these pushbacks in 2008, 2015, 2018, and followed up with new research twice in 2020, given that such pushbacks have intensified. And this is a pattern of abuses that has been going on for over at least a decade. Last March, during the border crisis between Turkey and Greece, we documented how Greek security forces in Evros detained, assaulted, and robbed asylum seekers before forcing them back to Turkey. Asylum seekers and migrants we interviewed independently told us that within hours after they crossed in boats or waded through the river, armed men wearing various law enforcement uniforms or in civilian clothes, wearing black balaclavas, intercepted everyone in their group. All said the men detained them in official or informal detention centers or on the roadside in Greek territory and stole their money, mobile phones, and bags before summarily pushing them back to Turkey. The majority described how the men assaulted them, including women and children, through electric shocks, beating with wooden or metal rods, prolonged beating of the soles of feet, punching, kicking, and stomping. Taken together, the interviewees described 38 deportation incidents involving almost 4,000 people, although some of these could have been double counts. And despite the numerous reports from non-governmental groups, because we were not the only ones documenting what was happening, these incidents continued and even intensified in the following months, and particularly during the lockdown period, while the Greek government at the same time was proudly saying that they managed to bring down the number of arrivals into Greek territory down to almost zero. So last July, we published yet another report documenting how Greek law enforcement, police, Coast Guard summarily returned asylum seekers and migrants from the land and from the sea borders. And for the very first time since I work on Greece, we even documented cases of collective expulsions of asylum seekers from deep inside Greece, people who already had some kind of documents. People were rounded up by Greek police officers in Diavata camp, which is in Thessaloniki, 400 kilometers away from the land border, taken by bus to the land border and expelled through the Evros River. We also interviewed for that research published in July, 6 asylum seekers, including a 15-year-old unaccompanied girl, who described 3 incidents in March and in April in which Greek Coast Guard personnel, Greek police, and armed masked men coordinated and carried out summary returns to Turkey from islands, from Rhodes, from Samos, from Simi. And again, this was new for me because it was the first time we documented collective expulsions of people who managed to reach Greek soil, Greek islands, and then suddenly disappeared. All of them said they were picked up on the island soon after they landed, placed on larger Coast Guard boats, and once they were back at the sea border, they were forced onto small inflatable rescue rafts with no motor and cast adrift near Turkish territorial waters. At the time, senior EU officials met with Greek Prime Minister Kyriakos Mitsotakis at the Greek-Turkey land border in March, praising the government for protecting the border and referring to Greece as the EU's shield. Throughout those years, the successive Greek government simply denied the allegations while failing to support genuine investigations into the patterns of abuses documented. Inquiries by prosecutors throughout this decade have brought no results, while internal inquiries have consistently concluded that no such pushbacks have taken place. An inquiry launched a few years ago by the Ombudsman's Office that is tasked with investigating law enforcement abuse has again brought no results. And to my knowledge, no one has ever been held accountable for such abuses, while the evidence is overwhelming. Last October, a group of 29 non-governmental groups, we decided to come together to call on the Greek parliament to open an inquiry into the abuses and examine specifically whether these abuses are part of a de facto government policy. And still, this call remains unanswered. In September, a legal complaint was filed to the European Commission by non-governmental groups calling on the European Commission to trigger an infringement procedure against Greece for its systematic breach of EU law in its treatment of asylum seekers, including because of pushbacks. And it's worth saying that there was already an infringement procedure initiated back in 2010 that again brought no results. Greece is not the only country conducting such pushbacks, but it's one of the countries where there is vast evidence about it happening. In September, we published a report on Cyprus, documenting how Cypriot Coast Guard forces summarily pushed back, abandoned, expelled, or returned more than 200 migrants, refugees, and asylum seekers coming from Lebanon during the first week of September, without giving them the opportunity to lodge asylum claims. The shocking images of migrants and asylum seekers abused by Croatian authorities are also part of this persistent and well-documented trend of human rights violations taking place at European borders. Evidence is massive, and they are also a reflection of the widespread impunity of European Union member states, border authorities, and demonstrate the urgent need to address this in a systematic manner. In an article published just this morning by the EU Observer, a redacted chain email from Frontex made available following a Freedom of Information request to the outlet shows that the Hellenic Coast Guard received orders to push migrants back into Turkish territorial waters. In the email, it says, Hellenic Coast Guard liaison officer informed a crew about an order from his authority to transfer the migrants back to the rubber boat and transport them into Turkish territorial waters. We had asked Frontex about this specific incident that took place in March, involving a Danish Coast Guard crew, and at that time, we were told it was a misunderstanding. The calls made in July by Commissioner Johansson to create a new mechanism to monitor and verify reports of pushbacks gave real hope that the Commission could finally uphold the protections of asylum seekers against abuses that EU law guarantees. We hope the Commissioner's stated intentions could guide the work of the Commission. But unfortunately, I think the proposition of border monitoring mechanism included in the pact will fall short of what is truly needed to address widespread impunity for those committing such abuses. Because we've seen how national mechanisms have offered no accountability for the last decade, at least in the case of Greece. I believe that turning a blind eye to violations of fundamental rights by member states sends the message to abusers that it is okay to secure EU borders at any price, including at the expense of fundamental rights and European values. And it should not be like that. Thank you very much.
Thank you very much, Eva, for those insights. And a brief reminder to all attendees to please send your questions, if you have any, through the Q&A function at the bottom of your screens. I'll now pass on to my colleague Barbara Ioannon, who is Head of Programs and Advocacy at Refugee Rights Europe, and who will be outlining key findings from our newly published Europe-wide report on pushbacks. Over to you, Barbara.
Thank you, Stephanie, and thank you to you all who are following our online event. As mentioned by Stephanie in the introduction, Refugee Rights Europe and the End Pushbacks Partnership have just released a report on pushbacks and rights violations at Europe's borders. To our knowledge, this is the first report of its kind, analyzing evidence and field information from a whole 20 EU internal and external land and sea borders. It collates detailed evidence submission from partners of the End Pushbacks Partnership, which included voices of experts by experience, that's to say, people on the move having experienced these pushbacks firsthand. And the analysis is deeply disconcerting. We all knew that pushbacks and violations at borders were commonplace in Europe, but the report reveals the sheer thereof. While the evidence included in the report is certainly not exhaustive, its volume, combined with rigorous research, has allowed us to draw out several conclusions, which I would like to briefly outline today. First of all, the systematic use of pushbacks is nothing new, but the situation is clearly deteriorating. While the use of pushbacks has been resorted to at certain European borders for decades, such as at the Spanish-Moroccan frontier, in the central Mediterranean, or even as mentioned by Eva at the Evros border, we have witnessed a staggering increase in the practice from 2015-2016 onwards. And according to our report findings, we appear to now have entered a third phase since late 2019, early 2020, where pushbacks are widespread across Europe and increasingly violent as well. Pushbacks also appear to be increasingly carried out by member states with a systematized approach. That's also something mentioned by Eva in the previous presentation. And that's especially the case along the Balkan route at Greece borders and as well as in the central Mediterranean. In a number of cases as well, and not only in Greece, the direct or indirect support of Frontex is also evidenced. Secondly, we've been able, with this report, to draw up a typology of pushbacks across the EU. And the main methods identified are as follows. We have hot pushbacks or on-the-spot pushbacks, of which we have evidence at the border between Spain and Morocco, at land and sea borders, as well as between Bulgaria and Turkey, Greece and Turkey, both land and as well, and at Croatia's border with Bosnia and Herzegovina. These pushbacks are often accompanied by a militarization and physical closure of borders. They're usually extremely violent, as in the examples given as well by Eva in her presentation, and have led to severe injuries and even death. A second method we identify corresponds to the arrests inside the territory or at or close to the border, followed by refusal of access to asylum and summary returns. This is evidenced at many borders. For example, at French borders with Spain and Italy respectively, at the Italy-Slovenia border, or at the Greece-Turkey borders as well. In some cases, for instance, at the French-Italian border or at the Greece-Turkey land border, pushbacks are preceded by arbitrary detention. It must be highlighted that although in a number of cases, they are said to be operated under bilateral readmission agreements, these summary returns are conducted without due process. And these operations are often conducted with violations such as beatings, humiliations, verbal abuse, threats, and people's belongings. Our typology also distinguishes organized chain refoulement, mainly in the Balkans, from Italy to Bosnia and Herzegovina through Slovenia and Croatia, as well as pullbacks by other border countries. For instance, the report shows that we have evidence of pullbacks by Turkish authorities at the land border with Bulgaria, at sea as well, vis-à-vis Cyprus. And it's also one of the main methods used in the central Mediterranean to force people back to Libya. Speaking about the Mediterranean, we witness additional methods which are specific to the sea context. For instance, in the Western and Central Mediterranean, responsible EU member state authorities are preventing disembarkation or answering rescue calls with really long delays or not answering at all, and are not intervening themselves, but are rather directing third countries' border forces to take people back. As part of the sea context methods, there are also cases of pushbacks operated by private vessels, as in the case of Malta. And in the agency, attacks of displaced people boats are widely evidenced. Our third main conclusion with this report is that pushbacks have multiple forms of harmful impacts. Border violence obviously has detrimental impact on the mental and physical health of people on the move who've come to Europe to seek protection. We also have harmful impacts at EU level, as our analysis suggests that the lack of accountability and sense of impunity surrounding illegal pushbacks and related rights violations directly undermine the integrity and credibility of European legal frameworks and political commitments. By the same token, pushbacks risk having a negative impact on European social cohesion through the normalization of violence against newcomers and the instrumentalization of border management issues for political gains. Pushbacks contribute to the further polarization of our societies. One last conclusion I would like to highlight is that the responsibility of the EU is crucial and cannot be eluded. The EU contributes to the continuation of these pushbacks, firstly by failing to hold member states to account, and secondly by financially, operationally, and politically supporting third states who are known to perpetrate gross human rights violations in order to halt new arrivals onto EU territory. So to sum up, our report shows that pushbacks are an undeniable Europe-wide unlawful practice which can no longer be ignored, and we hope that it will contribute to an end of silence and inaction, and to the beginning of a Europe that truly protects its fundamental values of human rights and human dignity. Thank you very much.
Thank you very much, Barbara. And a quick note to say this report will be shared with all participants shortly after the event today. This leads us on to the last intervention of this panel by Mr. Henrik Nielsen, who is head of the Asylum Unit in Directorate General Migration and Home Affairs at the European Commission, and who will outline some of the EU institutional obstacles in holding member states accountable for these practices that we have just heard about, as well as proposed ways forward. Mr. Nielsen, the floor is yours.
Yeah, thank you very much, Stephanie. Good morning, everyone, and thank you for the opportunity to take part in this event. To start with, I think I need, of course, to reaffirm the Commission's position that any kind of fundamental rights violations are unacceptable, be it at the border or within the territory. And this has, as you said, actually, the Commissioner has stated that several times in public, but also raised it in bilateral with a number of member states concerned. And we are indeed deeply concerned about the many allegations we see. And I would actually tend to agree that the number of allegations have increased recently, and also the seriousness of those allegations have increased. And this is deeply disturbing, I would say. From our point of view, the important starting point is also that there can be no contradiction between, on the one hand, fully upholding the fundamental rights of each individual, but on the other hand, also ensuring strict border control and strict return policies. These are not opposing objectives. They can both be met without compromising one or the other. And that's also a key starting point for us. And I think the pact overall, both the communication and the proposals, reaffirms the Commission's commitment to both of those objectives. And again, not making any trade-off between them, and not eroding or proposing anything that would hollow out the right to access the asylum procedure on EU territory that we want to preserve. And it's a principle laid down in the Charter. Now, more concretely for us, when we speak about pushbacks, whether that is the right term or not, the core issues are exactly those: access to the asylum procedure for anyone on EU territory or at the EU border, as well as full respect of the non-refoulement principle for those same persons. And that's kind of the scope which is important to keep in mind. It's not necessarily the same thing, access to the procedure or respect for non-refoulement. And secondly, also the scope, so it's EU territory, including territorial waters and at EU borders. and that's the scope where EU law applies. The challenge that we often face, I would say, if we try to structure these cases a bit, is whether it's an issue of facts or an issue of law. The issue of law is in a sense easier if you see the brackets, because then, and I'll be very direct and take the concrete example of Hungary, if a member state introduces national legislation which we consider to be contrary to EU law, in this case, basically not transposing the Asylum Procedures Directive correctly, we can quite easily, in a sense, go to court, because it's a matter of the court to say who is right or wrong. How should EU law be interpreted, and is the national law provisions in line with EU law? It is very little a case of trying to prove anything or to rely on any kind of evidence. It's just a case of the law. And that's a bit what the EU legal order, in a sense, was meant to do. And there, as you know, with regard to Hungary, we have launched now a total of 3 infringement proceedings, which are pending before the court on their national provisions. The much more difficult one, and as also previous speakers has pointed to, is when we have issues related to the facts. So the whole issue of whether EU law has been complied with or not is dependent on whether we can prove or we have evidence or facts that shows that a certain behavior has happened or certain incidents have happened. To be very brief, what we very often face in our dialogue with the member states is just a complete denial of these facts. So we end up in a kind of word against word situation. We have one side saying this happened and the other side saying, no, nothing happened. There was no such incident. Possible variant of that is member states saying, yes, there was such an incident, but these people expressed no wish to apply for asylum, and they are not at risk of any persecution in the neighboring country. So there is no issue of the access to the procedure or issue of full law. But it's the same problem. It's a question of facts. What actually happened? What did these people say? How did the border guards actually act? What kind of considerations did they take into account before they decided to expel someone? For this, it is of course much more difficult to bring such a case to the EU court. The principle has to be that we need to rely on the national legal order to deal with that kind of allegations. That in itself can be seen as an obligation flowing from EU law. From the Charter, you can derive the obligation for a member state to launch a proper internal investigation of any kind of such allegations. That's in itself an obligation that member states should comply with, and that we also impress on them. But the basic route needs to be that this is followed up on a national level with complaints mechanisms, monitoring mechanisms, or what there might be. Now, that does not exclude per se that we can launch infringement proceedings for this kind of cases, but then we do need, first of all, to see a systematic behavior on the side of the member state, which means a systematic wrongful application of EU law, and then once again, very clear-cut facts and evidence that allows us to really bring that to the court, knowing once again that the member state is likely to simply deny any facts or any wrongdoing. So that's in a nutshell the challenge that we are facing. Maybe one word, if I'm not out of time, on the monitoring mechanism proposed in the screening regulation as part of the pact. So first of all, to see the context, to regulate now the screening phase of what happens at our border is a bit the gap. We have, in a sense, no common EU rules in terms of what should happen during the screening or the hotspot phase or the initial disembarkation, whatever you want to call it. So the screening is meant to fill this gap to harmonize. But to accompany this additional harmonization at EU level, we also want to fill the gap with regard to the monitoring. And it's a gap in the sense of that we need to recall that we have the Schengen evaluation mechanism in place for border control, and we hope to soon have the monitoring mechanism of the new asylum agency with regard to the asylum acquis. To make sure that we cover also the screening phase with monitoring, we included that in the proposal. On the scope, it's important to note that the monitoring is aligned with the screening. Now, the screening starts from the very first apprehension, or whatever you want to call it, of a migrant having crossed the external border. So in that sense, any risk of pushbacks are, in our view, within the scope of the monitoring mechanism, because pushbacks will naturally happen as soon as you have actually apprehended someone. So it is, in that sense, covered. Second point to stress the independence of the institution in the member state that will carry out this monitoring now. There are always limitations in terms of what we can do at the level of the EU to impose or instruct to member states which authority at national level should do what. That's a fairly basic principle that member states can decide how they organize themselves. but we can set the functional requirements in EU law, so the independence requirements, which we have entrusted the Fundamental Rights Agency to follow up on, and where there are also guidelines from the Council of Europe that can be used to more flesh out in detail what does independence mean and which institution would be suitable or not. That will also loop back to the new mechanism for national and EU strategies and reporting that we have put into the Asylum and Migration Management Regulation. So in that one, we will want to see member states reporting on what kind of mechanism they have set up for the monitoring, what the results are of that, and allow us also to make recommendations if we think it's not sufficient. So there is kind of a feedback or follow-up mechanism to link it to the setup of the monitoring. Perhaps just as the last word, this is now due to the screening proposal something that we want to harmonize at the EU level, but obviously nothing prevents member states from having national monitoring mechanisms in place today, which is only a good thing, and which, let's say, from a policy point of view, we encourage member states to have in place already now, and we know that there are good examples of that also in some member states. But I stop here for now, but I'm of course at disposal for any questions. Thank you.
Thank you very much, Mr. Nielsen, for these reflections. And now I'd like to move us on to our first Q&A section, which we will open with comments by Ms. Edita Tuta, who is focal point on migration at the UN Human Rights Regional Office for Europe. Ms. Tuta, over to you.
Thank you very much. Thank you very much for organizing the event and also for giving us the opportunity to share our reflection about monitoring and pushbacks. Just to maybe start with pushbacks, that in June, the Special Rapporteur on Migration and the Special Rapporteur on Torture issued their statement, and they raised concern that the pushback constitutes a violation of the prohibition of collective expulsion and the principle of non-refoulement. They called for investigating or reported cases of violence against migrants, holding the perpetrators and their superiors accountable and providing compensation for victims. During the last meeting of the Human Rights Council, the High Commissioner for Human Rights called for independent monitoring and verification in light of reports of pushbacks and collective expulsion at the sea and land borders of the EU states. Why
Sorry, Edita, I think your camera has frozen for now. Perhaps let's read out the first question and then maybe we can return to you. We have one anonymous question from the audience, and this is for Mr. Nielsen. And it reads, what are the next opportunities for civil society in Europe to input on the shape of the monitoring mechanism proposed in the new pact? Mr. Nielsen, did you hear that okay?
Yeah, no, that's fine. No, I mean, now we go into the legislative phase. So the Council and the Parliament have started to assess the proposals, including the screening one. And from our side, it's certainly important to keep the dialogue with civil society organizations. But also I expect the Council and the Parliament to also engage with civil society to get their input with a view to the two sides of the co-legislators defining their position. So we are open to continue the dialogue in terms of, let's say, positioning or changing or amending the proposal. From the Commission side, we'll have to await the first positions of the Parliament and the Council with a view to the negotiations. But we are open to continue the dialogue with any organization, also at this phase.
Thank you very much, Mr. Nielsen. I believe we will try again to hear from Ms. Tuta. Can you hear us, Edita? Okay. In that case, we have one more question for this round, and it is again for Mr. Nielsen. And It reads, you refer to legal remedies through EU law. So my thought is on the CJEU. What can the CJEU do to uphold the rule of law and the respect for fundamental rights by EU member states, taking into account that the EU Commission will not start infringement procedures against these member states? Over to you, Mr. Nielsen.
Yeah, I mean, first of all, I didn't say whether we will or will not launch any infringement proceedings. That's, let's say, an open decision case by case to be taken. So we reserve that right to do that, but under a bit the conditions I said in my initial intervention, that it's not necessarily easy, but that has not been excluded. The second route, as you might know, for issues to reach the European Court is through preliminary rulings. So referrals from national courts who might be faced with issues of interpretation of EU law that they may wish to refer to the EU court. But once again, to bring issues from the national level to the EU court in terms of assessing the facts and the evidence, I think is difficult. There again, it's the national institutions that need to do that. And it perhaps links, just to add that to what I said before, as a broader consideration to issues related to the rule of law. To uphold the EU legal order, whether it's in migration or other areas, we need strong national institutions and independent national courts to uphold also EU law. Otherwise, it will simply not work. And there is kind of no way that the Commission and the EU court can compensate for the absence of such institutions at national level. So it's also a broader issue in that sense.
Thank you very much, Mr. Nielsen, for that answer. And this will bring us to our second panel on the action civil society is taking to document and investigate pushbacks, and further reflections on the already mentioned independent border monitoring mechanism proposed in the new pact. Our first speaker is Christina Vavia, who is member of the group Forensic Architecture and lead researcher on the group's Evros investigations. Christina will be introducing us to Forensic Architecture's work in documenting and investigating illegal pushbacks. And a quick note for the audience that this intervention will be accompanied by a visual presentation. Over to you, Christina.
Thank you, Stephanie, and it is a pleasure to be here. I'm going to share my screen quickly and present to you very briefly the work of Forensic Architecture, which is a research agency based in Goldsmiths University of London. We are an interdisciplinary team that undertakes spatial and media investigation for cases of human rights and environmental violence, and we collaborate with NGOs and justice groups to present our work to national and international courts, the UN, as well as on the media and in cultural institutions. We are funded by the European Research Council as well as human rights and technology grants. And we have conducted several investigations of pushbacks at the Evros marriage border, as for example is the case of Ayşe Erdogan, a primary school teacher who was traveling with two friends, Kamil Yildirim and Talip Niksar, fleeing persecution in Turkey. They entered into Greece through the Evros marriage river in May 2019, and they sent GPS pins to their family, which give us a digital trace of their location. Then they also sent photographs and videos broadcasting the request for asylum, and we are able to geolocate some of this footage, like this image, which is taken outside the Greek government building. We could thus prove that they were within Greek territory, and then they handed themselves in and were taken to a police station in Neo Himonio, where they sent a final location pin. Then they were picked up by border guards in Turkey, near the town of Serenköy. And Ayşe was sent in one of the most notorious prisons in Turkey. Of course, in other circumstances, we don't have such compelling evidence with geotag locations and images to work with. In fact, because the Evros marriage river is a military zone, and because when migrants are arrested, their phones and personal documents are usually confiscated or thrown to the river, there is very little evidence of this practice beyond witness testimony to refer to the issue of facts that we were talking about before. So we collaborated with Human Rights 360, and in November 2019, we traveled to Athens to interview 4 witnesses who had experienced pushbacks. We used architectural and gaming software to help witnesses reconstruct their experiences only from memory. And the witnesses described buildings they were held in, vehicles they were transported in, the attire and gear of the operatives pushing them back, as well as river landscapes that they were forced to cross. The process of reconstruction that we call situated testimony helped them remember more details from their experiences as the scenes became more visceral and somehow immersive. So using satellite images, maps, official documents, videos and photographs and meteorological data, we were also able to corroborate these testimonies and identify some of the places and actors involved, including Greek police, border guards and military, and sometimes civilians and foreign-speaking personnel. This was the case of Fadi Alali Al-Jazim, a Syrian man that held the refugee status in Germany and traveled by plane to Thessaloniki and then Evros in order to find his 11-year-old missing brother. Fadi was illegally arrested, detained, and expelled to Turkey while his documents were confiscated. After unsuccessful attempts to regain his passport through the German embassy, he tried to enter Greece and the EU and was pushed back more than 10 times until he finally arrived in Greece, where he spent 2 years in hiding. Fadi's asylum was finally reinstated in December 2019, and he currently resides legally again in Germany, but his brother is still missing. He reported to us that he heard people speaking German, a language that he recognizes well from his lived experience and of course because he was taking German classes. He reported that these people were involved in the pushback operation. His case was just submitted by the Global Legal Action Network to the UN Commission for Human Rights. This is another case, the case of Kuzi, who is using a pseudonym, a Turkish national who was pushed back 5 times, beaten and tortured at the border so that he, quote, learns not to come back again. Needless to say that neither of these witnesses had access to a lawyer or were given the opportunity to apply for asylum. They were exposed to the cold, starvation, and their lives were put at risk from being pushed back. We were also able to analyze the only footage that has surfaced from these pushbacks that was obtained by Der Spiegel from an anonymous source, capturing people moved from the Greek banks to the Turkish side of the border. We geolocated it by analyzing the sun's orientation, by finding distinct features on the landscape, and by measuring the width of the river. We found it was about 300 meters away from a Greek watchtower. It is also important to know that we have evidence that pushbacks were happening by both the Syriza and the New Democracy governments, and that this practice is routine, systematic, and widespread. There is a simple modus operandi. Asylum seekers are put in vans without insignia and blocked windows. They are taken to police stations, detention centers, and are often hidden in the forest until it gets dark. And then they are taken to the river and forced onto boats to take them to the Turkish side. So this is the work we were doing when the tensions erupted in March 2020, when migrants were pushed to the Evros-Meriç border by Turkey. So naturally, we started an investigation and collaborated with Bellingcat and Lighthouse reports. There we had hundreds of videos that we geolocated and tracked. Some of them were streamed on Facebook Live, meaning that we could trust their metadata. We synchronized others through distinct sounds of gunshots. In fact, all the blue markers that you see on this timeline are sounds of gunshots. And we were able to identify the location and trajectory of the people who were injured, as well as the identity of the people who died. That was Mohammed Gulzar on the 4th of March and Mohammed Al-Arab on the 2nd of March. There is an overwhelming amount of evidence that indicates that these shots came from the Greek side. To deny any event of violence is to break the fundamental trust that the European people have on their governments. We are appalled by the response we received by government officials, calling these reports fake news. The only legitimate response to such grave allegations is to start a full, independent, and scientific investigation. All our results are available and have already been submitted to the Greek Ombudsman. We urge the Greek government and the EU Commission to take a stance and to stop flirting with authoritarian tricks of denial of scientific evidence. Here you can see Ioannis Lagos, an MEP for Golden Dawn, who was just convicted for his participation in the criminal organization. He joined other far-right groups in Evros on the 5th of March to promote his xenophobic agenda. We urge European bodies to recognize that the dismissal of this evidence as fake news directly offers a license. It grants a full permission to extremist groups to continue the violent work. This evidence essentially presents the EU with a very clear choice. Who do we want to be? Denialists or protectors of human rights? Thank you.
Thank you very much, Christina, for these insights into really a crucial way of shedding light on these often invisible and silent practices. And I encourage everyone to familiarize yourselves with forensic architecture's other related investigations, such as one on the somewhat controversial European Court of Human Rights decision on the NT and NT versus Spain case. The investigation contests the arguments presented by Spain and accepted by the court that the claimants had legal pathways to apply for asylum, and it does so comprehensively using spatial analysis, official data, human rights reports, as well as witness testimony. This leads us on well to our next speaker, Anna Brambilla, who is a lawyer at the NGO ASG and who will be offering insights into the strategic litigation that ASG engages in to hold perpetrators accountable for pushbacks and to safeguard human rights at borders. Anna, the floor is yours.
Thank you very much. Thank you for the opportunity to be here. And as ASG, we work since a long time on south border, but also on internal border in Italy. Above all, we operate on Italian-French border and Swiss-Italian border, and now we are focused on Slovenian-Italian border. We use strategic litigation, try to change the situation on internal border. We know that the situation on internal border is different from the situation on external border, but also on internal border we can see the use of violence and illegal detention, pushback of unaccompanied minors and chain pushback. And regarding strategic litigation on French-Italian border, we mainly support the strategic litigation that has been used by French lawyers against the pushback of unaccompanied minors. Above all, in 2018, a French lawyer with the help of Italian and French organization filed different strategic litigation in front of administrative court in France. And in some of these cases, the judge decided that the pushback from France to Italy of unaccompanied minors without legal guarantee are illegal. Unfortunately, the situation of the unaccompanied minors and pushback from France to Italy continue. The police usually change the date of birth of minors, and so for that reason, the French border police continue to push back minors in Italy. In last year, the situation of the accommodation of unaccompanied minors in Italy has changed due to the change also of national law. But in the period 2016-2017, the situation of unaccompanied minors in Italy and above all near the internal border was very serious. And for that reason, in 2017, we asked to the European Court of Human Rights to have an interim measures for an unaccompanied minors who was she was a female, she was an asylum seeker, she was in a Red Cross center near the border between Italy and Switzerland, and she was she was hosted with adults and family, and her situation was very serious due to the torture that she got in her country of origin. And so we asked several times to the Italian authorities to transfer her in a specific center for minors, but we didn't receive any answer. For that reason, we asked to the European Court of Human Rights and interim measures, and we got in few days the order to transfer her in a specific center. And as I mentioned before, now we are focused mainly on the border between Italy and Slovenia because of the pushback from Italy to Slovenia, and Slovenia and Croatia and Bosnia. And we know that this type of pushback happen also on Adriatic ports, and that the European Court of Human Rights has already, Italy has already been condemned by the European Court of Human Rights for the pushback from the Adriatic port to Greece. More or less the mechanism is the same, because Italy used a readmission agreement to give a legal, in a way, to do this pushback in a legal way, but we think that these pushback are all illegal, above all when we are in with the asylum seeker. We present now an appeal in front of the National Court in Rome for a young man from Pakistan who has been pushed back from Italy to Slovenia, Croatia, and Bosnia. And when he arrived in Italy, he tried to ask for asylum, but even if he tried to ask for asylum, the Italian authorities sent back him to Slovenia and so on in Croatia and in Bosnia. And we decided to appeal in front of the National Court, try to prove that Italy must be held responsible not only for the pushback from Italy to Slovenia, but also for the chain pushback back to Bosnia, on the basis, because we think that on the basis of numerous reports, the chain pushback mechanism must be considered well known by Italian authorities. We also highlighted also that Italian authorities have not in any way considered the or verified the risk of inhuman and degrading treatment, both during the refoulement and for the situation of accommodation in Bosnia. And we ask to the judge to order the issuance of an entry visa to allow to this guy to enter in Italy and ask for asylum. We will have the hearing in a short time at the beginning of December, so we hope to prove that this arrive in Italy, and we will give news about this proceeding. Many thanks.
Thank you very, very much. Now I'd like to pass the floor to Josephine, who is head of advocacy at the European Council on Refugees and Exiles, and who will be outlining key recommendations that were put forward in a joint statement issued by several NGOs in reaction to the proposed border monitoring mechanism in the new screening regulation. Over to you, Josephine.
Thank you very much, Stephanie, and thanks very much for Refugee Rights Europe and Human Rights Watch for organizing this and inviting us to speak. I would like to focus my input on the proposed Pact on Migration and Asylum that was published end of September by the European Commission. as there are indeed several aspects of the proposals that are worrying from a perspective of compliance with fundamental rights at the EU's borders. So I want to give a few examples of those proposals where we see risks for fundamental rights violations before focusing in on the proposed monitoring mechanism at the borders. So we are concerned for several aspects of the proposals, starting with the proposed screening process at the external border, where we don't see adequate safeguards for individuals who would be subject to that screening process in the form of legal aid, legal representation, and would also want to see that the grounds for refusal of entry, as well as the right to appeal such a refusal, are more sufficiently specified within the legislative text. Also, we believe that the introduction of a mandatory border procedure, which will apply to certain cases of individuals, constitutes an increased risk of fundamental rights violations. We say this because we just conducted a study commissioned by the European Parliament that looked at the implementation and application of the border procedure as within the remit of Article 43 of the Asylum Procedures Directive, in which we have found that the border procedure leads to systematic and extended use of de facto detention, and that the procedural safeguards that are in place currently, in particular the right to information, legal assistance and interpretation, are not at all or only restrictively applied in practice. That is something that, of course, raises concerns when we look at the mandatory rolling out of such a procedure throughout the EU and at the external border. In addition, the fiction of non-entry, which is a component of both the proposed screening process and the border procedure, may in certain circumstances undermine the right to asylum, the principle of non-refoulement, and the right to an effective remedy under the Charter. And then the final concern that I would like to raise in this short intervention is the newly proposed crisis regulation, which will, where it is suggested that member states will be able to suspend the registration of asylum applications for 4 weeks, which may put people at risk of detention, refoulement, and affect their rights to adequate reception and basic services. Thus, on a whole, in the current form, we believe that the pact proposals would increase the risk of violations of fundamental rights at the EU's borders. So in order to address this, we really call on the co-legislators, as the proposals are now in the hands of the co-legislators, to remove the harmful elements of the proposals and increase the additional or include additional safeguards. ECRE is currently preparing detailed comments on the proposals and will be making suggestions as to how that could be done. I would now, however, focus on a very promising aspect of the proposal, which has been mentioned before already, namely the suggestion of the establishment of independent border monitoring of fundamental rights at the national level. We welcome this initiative and think it is a step into the right direction. It is based, we hope or assume, on the recognition that a crucial part of addressing the consistent and widespread violations, and we have just heard for around an hour of how consistent and widespread those violations at the borders are, is to ensure that there is independent monitoring carried out in a systematic way in all EU member states. However, we believe that what has been currently proposed is too limited to have the desired impact. Changes are needed on 4 key areas that I would like to run through just now. This builds on a joint agency statement that Stephanie has already mentioned, which ECRE and 7 other organizations have published last week. It is available on the various websites and will be shared afterwards with participants as well. So the first of these concerns where we want to see change is that the scope of the monitoring has to be expanded to apply to all alleged fundamental rights violations by national border management authorities or during border control activities. The current proposal sees that mechanism limited to only the screening process. It is clear to us that any limitations of the mechanism to a specific geographic area or a specific procedural aspect will undermine the effectiveness and leave out blind spots where violations can continue. Related to this, we also would like to see a specific recognition that the mechanism can act on complaints and can receive complaints by individuals who may have left the territory of the state where the mechanism has been established. And this is, of course, to reflect and act on the specific issue of pushbacks and collective expulsions where individuals are removed from the respective territory. The second change that we would want to see is a firm establishment of the requirement of independence of the mechanism that has to be ensured, firstly, by requiring the involvement of independent national authorities, such as national human rights institutions or ombudspersons who are regularly assessed for their independence, or civil society organizations and international organizations. Those organizations have to be part of the mechanism. In addition, we would also like to ensure that mechanisms are not dependent only on the government for funding, but that EU funding is made available to ensure that financial resources are adequate to the task of monitoring that needs to be carried out. The third concern that I want to highlight is the need for increased accountability and defined accountability to ensure that member states investigate allegations, put an end to abuse, guarantee access to justice, and ensure transparency. I think we can all agree after everything that we have heard today and the intentions behind the mechanism, as far as we understand from the European Commission side, is that the litmus test for the mechanism will really be to what extent it will trigger concrete action should a risk for fundamental rights violation or an alleged violation be notified to it. So the proposal itself really needs to specify how that follow-up process is supposed to look like. We would foresee that accountability to potentially affected individuals should also entail guarantees for access to or information about the mechanism, legal advice, and effective access to justice, as well as an obligation for the mechanism to public and periodically report on its activities, the violations that it has identified, and what follow-up activities have taken place. Fourth and finally, there need to be repercussions if member states fail to act. And that failure to act should start from situations where a mechanism has not been set up, where a mechanism has been set up but is not, there's no cooperation with the mechanism, or where the findings of the mechanism are not followed. This, in our view, should include the withdrawal or withholding of funding by the European Commission, which, given that in the next EU budget cycle, there's a suggested precondition for member states to receive funding that relates to the implementation of the EU Charter, is a possibility that we would like to see. And of course, we would expect that the findings of the mechanism will also inform the European Commission's assessment of the compliance of a member state with the asylum acquis and potential infringement procedures. Thank you very much. And we'll leave it at that.
Thank you so much, Josephine. And to confirm that all attendees will receive a copy of the joint statement referred to after today's event. I would also like to briefly take this opportunity to thank the other NGOs involved in developing the recommendations that were referred to, particularly also the Danish Refugee Council, who coordinated this initiative. This brings us on to our second Q&A section, which we will open by returning to Ms. Tuta of the UN Human Rights Regional Office for Europe, who is back with us now after some technical issues. Ms. Tuta, the floor is yours.
Yeah, thank you very much for the second try, and so apologizes for these technical problems. And just so coming back to my reflection on monitoring, because we are so talking a lot about monitoring mechanism, but maybe some reflection from our perspective, what for us, for OHCHR, monitoring And as I already mentioned, it is like a key element. And because we think it is very important, it is very important, first of all, to provide practical recommendation on how to ensure full respect and protection of migrants' human rights, regardless of their status, but also to better understand the challenges faced by the member states, but also by migrants. But what is very important, that monitoring activities should be placed within a broader strategy to ensure follow-up, but also investigations. Our monitoring has helped provide important input to review processes of human rights mechanism, who were able to take on an important follow-up role and strengthening the recommendation based on the information received. So accordingly, the monitoring could help civil society undertake advocacy efforts to ensure recommendation to be followed up on. Conducting our monitoring work, we using our guidelines on human rights at international borders, and also guidance on human rights protection of migrants in vulnerable situations. At the moment, we are working on a new chapter in our manual on human rights monitoring to have chapter focusing on monitoring in the context of migration. Hopefully, the publication will be ready next year. We really welcome the proposal in the pact about the independent monitoring system, and also welcome the statement issued by non-governmental groups in response to the proposal. We do believe that it is really very important to put in place a structured, robust monitoring system with broad scope to cover all fundamental rights violations in the context of migration. We think that that independence, it is the crucial element for the effectiveness of the system. And then so we can also be inspired by the Paris Principle in terms of independence, different bodies at national level. We think also that financial resources are very important, and to have the mechanism which contributes to accountability. European mission, but also other partners advancing such a mechanism. Thank you very much.
Thank you very much, Ms. Tuta. And this has led us actually to our first question in this Q&A, which is again related to the proposed border monitoring mechanism, and it is again for Mr. Nielsen of the European Commission. Thank you for allowing us to address you with a few more questions. It is from Elisabetta Deida, who highlights the important work of the Border Violence Monitoring Network and poses the following question. How come the allegations of pushbacks by Croatian authorities did not affect the decision of the European Commission regarding the readiness of Croatia to enter Schengen? Over to you, Mr. Nielsen.
Well, I think from our side, we did take that into account in the sense of assessing whether Croatia meets the criteria for the border management part of the Schengen acquis, but also to recall that that's in the end the decision of the member states whether to consider those criteria fulfilled or not. Then one can discuss whether the situation has changed since we made that recommendation or not. But still, now it's in the hands of the member states to consider that. So we will not review or go back on our previous assessment at this stage.
Thank you, Mr. Nielsen. And one more closely related question, which reads, what would adequate evidence look like in order to hold member states accountable? There are numerous videos and testimonials documenting illegal pushbacks. So what more would be needed?
Yeah, it is, of course, a good question, but I really can't speculate on that because one would have to decide on a case-by-case basis, taking all issues into account. First of all, the systematic nature of the possible misapplication of EU law, all the facts at our disposal, but also the views of the member state in question. So to define that in abstract, I'm afraid I'm not really able to do. But also to note perhaps that it could be a key issue for actually the court to tell us, because that's also an issue that we are facing. We don't have any case from the court so far that would actually give us guidance on what the court would expect in terms of evidence to be convinced. So that's part of the challenge that we are facing.
Thank you very much, Mr. Nielsen. That was also a very interesting point regarding guidance issued by courts potentially on the type of evidence that is needed. I would now like to move us on to our third and last panel for this event, where we will hear the reflections on potential ways forward by members of EU institutions and agencies, as well as the Council of Europe. Our first speaker will be MEP Tineke Strik of the Greens Group and member of the Committee on Civil Liberties, Justice and Home Affairs, who has been extremely active on the issue of pushbacks in recent years. Ms. Strik, the floor is yours.
Thank you very much. Thank you for organizing this event and of course also for inviting me. And let me start by paying tribute to all the NGOs and investigative journalists who have fueled this debate time after time with their consistent reports on these flagrant violations of core rights, because these are core rights: the right and access to asylum, right to dignity, and prohibition of torture and degrading treatment. This is all at stake at our external borders. I would like to elaborate a little bit on what are now actually the real gaps that we need to solve. Is it a lack of information? Is it a lack of rules? Or where should we put our attention to? Because it remains already for a long time. I remember, in June last year, I was member of the Parliamentary Assembly, and there I presented a report and a resolution on pushback practices along the European borders. And that was partly based on a working visit I paid to the Croatian border in January that year, but also on many reports consistently pointing at practices and even also policies. I mean, it's very clear, it has been remarked already, that it's not only about incidents, but really structural practices, and sometimes also accompanied, evidence-based, accompanied by instructions from the governments. Think of Malta, Greece, but I think also Croatia. So I don't think there's a lack of information that we have. But you see time after time that this information, these reports are being discredited. And therefore, when I entered the European Parliament last year and the LIBE Committee, I asked the LIBE Committee to request on Fundamental Rights Agency to do an investigation of the pushback practices and policies at the external borders of the EU. So I'm thrilled that Fra is also in this panel, because any moment we await the release of this report, so maybe Thomas will already say something about this. But actually it's awkward that we need something like this, and hopefully it will form a more basis for follow-up and actions. Do we have a lack of rules? Actually, I don't think so. We have the Charter, which is clear. We have the Asylum Procedures Directive with mandatory rules on access to an asylum procedure. We have the Schengen Border Code requiring a decision on entry or refusal of entry and the right to appeal. We have our external sea border regulation for joint operations of Frontex and the member states. There may be some room for improvement though, if I look now at the Returns Directive, where there's an optional clause from member states not to apply the Return Directive in border regions. Well, that may mean that some procedural safeguards are not complied with. So in my recast proposal, in the recast proposal of the Commission and the report of me as a rapporteur, I also proposed to delete this optional clause. So make sure that, especially in border regions where people are very vulnerable, all the safeguards are in place regarding return. And maybe there could be more detailed provisions in the Schengen handbook on the requirements for what should be there at the borders. But actually, I think in principle, there are sufficient rules. So the problem is actually in the question why they are not applied. There's already a lot been said about the lack of independent monitoring. But there's also, I think, a clear lack of enforcement of the rules and accountability in case of violations. And I think the impunity, which is lingering already so long, has really effectively promoted illegal actions. And even political silence, it implies improvement. And some governments from Croatia and Greece, they also said to me, look, the member states, they agree with our behavior. They sometimes even approve it. And I think also the fact that the Commission is so often silent can be explained as an approval. So there's not a lot of incentives for the member states to change their behavior and to comply with the rules. And I think this really urgently has to change. Now, there was already a lot of debate on the screening regulation proposal, and Johansson is always referring to it as that would prevent pushbacks in future. I really agree with Josephine Lippe and all the NGOs that came up with their statement that it is to be welcomed, but it's not enough because pushbacks do not take place at those formal accommodations and the formal procedures, but they take place on other places where there are no eyes on authorities. And so therefore I think it is of course a good first step. So let's see those national bodies, but we really need to have more criteria because at the moment not all national bodies are independent enough or have restrictions in their mandate. And therefore, there should be more detailed provisions as to where those national bodies, what their mandates and rules should be there. These rules should be clear and objective. And they surely must have access to all data, all spots. They must be able to do unannounced visits, etc., etc. And compliance with these obligations should also be monitored. So there should be the monitoring system, so to say, in a transparent way. And that's not enough, of course. What's also been said, we need to have safeguards that signals, complaints are followed up in an effective way. And so that they are dealt with by an independent body and not by the Minister of Interior, for instance, which you often see, that there's legal aid accessible and that there's a possibility to ask for review or appeal if things are really not taken seriously enough. I think, and that all needs to be monitored and enforced by the Commission. And there I really see big problems. If you see, look at the Croatian example, this is not really encouraging. A year ago, we got the position of the Commission that Croatia was meeting the requirements for exceeding the Schengen area. And their mention was made of the monitor mechanism. Now, I really find it very peculiar that there it was said the money goes to UNHCR, Croatian Law Center, and everything would work fine. And that it was needed that I went with some of my Green colleagues to Croatia, asked the Secretariat of State where the money was spent at, and then she said to me, well, we just spent it on some training, but most of it just went to the border control. Now, I confronted the Commission with that, but it's and they were embarrassed, but it's embarrassing. Actually, they could have checked so easily. They could have had this information for such a long time. And now there are more attempts being made to build up a monitoring system. But up until now, the violations keep on going on and they become even more blunt and even more serious. And still, the Commission did not change its conclusion in the end that Croatia is ready for exceeding the Schengen area. I just heard Mr. Nielsen said, yes, it's now up to the Council, but actually it's strange. I mean, if there are new evidence, new information, the Commission can, of course, review its position, because it's an important basis for the Council to do its negotiations or discussions on. And then you're only talking about Schengen, but there's still this possibility for enforcing compliance, for starting, doing investigations, for ensuring compliance with the access to asylum and prohibition of torture. And we didn't see anything on that yet, also not with Greece, with Malta, with so many countries where we have serious signals from. And the Commission actually says it wants to make member states more responsible. It wants to responsibilize the member states. That's really important, because the Commission cannot do everything on its own. But I think it's really an indispensable element of that the Commission shows it's ready to use its power as a guardian of the treaty, that it's really ready to push and to take steps in order to enforce compliance through infringement procedure. Now, we had this embarrassing situation regarding the Greece shooting incidents that the Commission said in the Libe Committee, look, the Commission is not an investigative body, and this is what many officials repeat. But, you know, compliance enforcement is not only by what is on the legislation, it's also by how the legislation is being applied and interpreted. And I think if the Commission doesn't have the capacity of really doing a scrutiny on that, even if there are serious signals, we really have to reconsider the capacity of the Commission. It should actually be an investigative body if necessary. Now, the Schengen evaluation mechanism is going to be reviewed, and it might very well be the case that fundamental rights will become an important element. So hopefully that will change something, but still we have the normal task of the Commission in enforcing compliance. Now, a few words on Frontex, because this is also very an urgent issue at the moment. Of course, we now see, I think, also a crisis between the Commission and Frontex. Now you see that the Commission is also publicly criticizing Frontex, asking questions to Frontex. We also try to put pressure. The Schengen Scrutiny Group has asked a lot of detailed questions to Frontex. We really want Frontex to answer in time before Frontex will be in the Libe Committee to give explanations. But I can tell you, we will reconsider after the hearing in the Schengen Scrutiny Group if we can end over there. I really think if you look at the Frontex, where the European Parliament and the Commission has even more responsibility, perhaps. Then and also the structural violations of the member states, we really need to do a thorough investigation of the whole system and what we can do more in order to bring an end to those violations. I'm very, very happy with the inquiry that the European Ombudsman has announced on the complaint mechanism, how effective and independent it is. And of course, it will also be taken into account and investigated why we have so little serious incidents reports and what is the follow-up of all those signals. But we should not only rely on the EU Ombudsman. I think that the Commission and Parliament and also the Council, each individual member state should take its responsibility and also not shy away in, you know, speaking up to each other. And not only looking away if things become difficult, because actually we're talking really about rule of law deficiencies, and it should be handled like that. Thank you.
Thank you very much, Ms. Strick, for these very clear and concrete recommendations as well, and also for your comments on the issues surrounding Frontex. That leads us on well to our next speaker, Mr. Tamas Molnar, who is Legal Research Officer at the EU Fundamental Rights Agency, which has of course also been given a new proposed role in the border monitoring mechanism that member states are to establish according to the new pact. Mr. Molnar will be offering reflections on this and other recent developments. Over to you, Mr. Molnar. Mr. Molnar, can you hear us? Are you there? Okay. We seem to be having some technical issues, so in that
can you hear me now?
Yes, we can hear you.
Okay, maybe there was some mismatch between one device and the screen. So just repeating my first two sentences, thanks very much, Stephanie, Madam Chair, for giving me the floor. And also I would like to express my gratitude that FRA has been invited to join to this intriguing and interesting discussion on issues of common interest. Speaking of the new border monitoring procedure as proposed by the Commission and Screening Regulation, I would remain first in this context, but giving reflections from a wider bird's eye perspective. So I'm not going to dwell into FRA's envisaged role, since it would be too premature, but the wider context of border monitoring is that there's nothing new under the sun. So, I mean, UNHCR, the UN Refugee Agency, also promoted that since the beginning of 2000 in a number of Central European countries. Participants and other panelists might recall tripartite agreements, memorandum of understanding, which have been concluded between UNHCR, border guards, and NGOs to monitor border control along different European land borders, especially in light of the recent or then upcoming EU accession of those countries. Some of those agreements are still in place. And then border monitoring in EU member states needs to cover all authorities and actors exercising public powers, which mean primarily and traditionally member state border management authorities, as well as Frontex, which is not a new kid on the block, but an emerging and more and more powerful actor to the extent of its mandate and involvement in operations at the borders or in third countries. So as of now, legally speaking, member states border authorities perform the lion's share of border control activities, where the bridgeheads of state sovereignty remain strong. In parallel with Frontex, which remains complementary and supporting in those actions. So as a result, most fundamental rights violations currently still occur from national law enforcement. When it comes to border monitoring methodologies, there's no need to reinvent the wheel. There are resources available out there. Just it's enough to think of the Trakai Forum, which was held in 2004, so more than 15 years ago. And in this context, intellectual exercise and thinking has started, or the Peace Institute's report from 2006. And also, there is much experience from the ground. There are multiple NGOs who used to work under the tripartite agreements, or still are still working at the border areas, and the information from them, the methods used by them, can be also an important source of inspiration. And why border monitoring? Besides ensuring greater transparency of the authorities' action, it goes without saying, monitor can also help identify problems, gaps, and training needs on various issues, especially fundamental rights. And it's a platform for dialogue among border officials, monitoring partners, NGOs, and other stakeholders. So transparency, a tool to identify issues, and then a platform for dialogue. So it can be a circular mechanism or circular tool. Then we think that a distinction must be made between monitoring mechanism on the one hand and complaints and accountability procedures on the other hand, They are not synonyms. The former, I mean, monitoring, cannot substitute the latter, accountability procedures. Monitoring, of course, can help prevent fundamental rights violations, hence less cases of accountability might emerge and less litigation before European courts, both at the national or the European levels, occurs. Then what should be the form of the monitoring? Again, it's nothing new, no surprise that a written agreement is needed, outlining the respective responsibilities between border guards and the monitoring body, which includes also the modalities on information and data sharing, as well as access to entry facilities, since an independent, and it was already mentioned, a structured and robust monitoring mechanism needs access to all places where authorities' action take place. As well as when formulating those written arrangements, it has to involve all actors. Again, I would highlight all actors, including independent institutions, NHRIs or national preventive mechanisms, as well as the prosecutor's office, where this body has such functions. For instance, in post-Soviet Central European countries, like, I mean, I'm Hungarian in my free time, and in Hungary or in other countries, the prosecutor's office has also this general responsibility to review the legality of the actions of other state organs. Then what to do? What are the possible elements or activities of such monitoring? It ranges from the periodic review of documentation and records provided by the border guards, then direct monitoring of day-to-day implementation of different protection standards, visiting border crossing points, visiting border, accompanying border guards and patrols, for instance, by mobile teams, then documenting individual incidents, but also training exercises and sessions on fundamental rights. And the reports which are drawn up at the end should detail the findings and recommendations of the monitoring mission. I'm almost at the end of my presentation, just two reflections. Of course, in monitoring, there are challenges. When these take place at remote locations in the woods or in the mountains, far from urban areas, or when authorities act in the middle of the night. So it's hard to be present and record incidents and gather evidence in those connections. And the last reflection is a bit zooming in on one emerging actor, Frontex. Since if we just see this context, legally speaking, there will be also monitoring mechanism to, how to say, provide watchful eyes on Frontex operations everywhere where the agency is present. These are the upcoming fundamental rights monitors. It's still on paper in the new Frontex regulation, but initially Frontex should have recruited 40 such fundamental rights monitors to be placed under the Fundamental Rights Office until the end of the year. Still, the process has started, and FRA cooperates with Frontex on this matter. Frontex sought our agency advice in putting in place a framework for setting up the future fundamental rights monitors, and FRA is now working closely with Frontex to develop guiding methodologies, assessing training needs, and drawing up materials for the future functioning of those new fundamental rights monitors. So a pilot project is in the pipeline, and we are assisting Frontex. And lastly, just as a form of shameless self-promotion, just to mention two FRA products, one recent one, which is a practical guidance for border guards. It's a do's and don'ts. It exists in such a pocket version. I will send you the link of this. It contains 10 practical do's and don'ts for border management authorities to help their daily work to uphold fundamental rights. And the next one, it's an upcoming thing, as MEP Strick, dear Tineke mentioned. The EP requested our agency to produce a report on fundamental rights at land borders. That will be sent to the Parliament in the coming days, and it will be later on also published. And I leave it here. Thanks a lot for your attention.
Thank you very much, Mr. Molnar, for these very detailed reflections also on the challenges in effective border monitoring, and the further comments on the role of Frontex, which has been the subject of much discussion recently. And of course, also thank you for pointing out the useful outputs that the agency has created recently. I would now like to hand it over to Mr. Drahoslav Stefanek, who is Special Representative for Migration and Refugees at the Council of Europe, and who will be offering insights into the potential role of the Council of Europe in ending pushbacks at European borders. Mr. Stefanek, the floor is yours.
Thank you very much. Okay.
Can you hear us okay? There we go.
Yeah, so sorry. Yeah, it got frozen. And thank you very much. I almost started. I would like to thank the you organizers, Refugee Rights Europe and Human Rights Watch, for including us, for inviting me to address the webinar. Let me again to say how much I appreciate the work and the contribution of the civil society, and this is confirmed clearly during today's webinar. I would like to recall the words by Tineke Strick, who said that the core rights are at the stake here, and we are speaking about the core rights. In the European Convention, we don't have explicit references to the pushbacks or non-refoulement in the convention, but according to the jurisprudence of the court, which is clear, and there have been many cases referring to Article 2 of the convention, right to life, and Article 3, prohibition of torture, and that those articles include and contain the prohibition of refoulement, non-refoulement, and pushbacks concepts. And I would like to also underline that those articles are not possible to derogate from, in accordance with Article 15 of the convention. Pushbacks are high on the agenda also for us. I can tell you, and we are following closely the developments. I think it's #1 top issue now recently, and we welcome also the contribution of Commissioner Johansson, who called on to investigate the alleged pushbacks happening in the Mediterranean and agency. So and as you know, the meeting of Frontex management board took place on 10th November, and there were some conclusions, and I think it will result in a creating a kind of working group which will deal with those allegations. I'm also myself member of the consultative forum. I see also some other colleagues who are also the members or associated with the work of the consultative forum to Frontex. Several entities of the Council of Europe are actively engaged in this issue and following of the issue. I would mention especially CPT, Committee on Prevention on Torture, which was I think not mentioned by the previous speakers. The CPT conducted a visit emergency visit in March to Evros area, and I would like to make your heads up because the CPT will issue tomorrow actually the report from that mission, and that can be definitely interesting reading. I haven't seen the report, but it will be issued tomorrow, and also with the response of the Greek government. So please read it carefully, because I will do the same. Also, the CPT undertook an emergency visit to Croatia in August. Of course, I'm expecting the report will will come later, but that can be interesting reading definitely too. So speaking about the monitoring and the new new proposals by the European Union, which was in the new EU Pact on Migration and Asylum, which was launched on 25th September. Of course, there we envisage the national monitoring mechanisms in EU 27 member states. But I would like to also offer and the expertise and the practice and the knowledge and know-how of the CPT as one of the monitoring bodies of the Council of Europe, which can definitely help, and which also is cooperating closely with especially with NPMs, national preventive mechanisms, and ombudspersons and other bodies. I also turning also to the proposed new monitoring mechanism on the screening. I would like to also recall and support actually the call of the civil society organizations in the joint statement, I think, which was issued I think on 10th November. I totally agree that it should not be limited only to the screening procedure. I don't think anything much will be revealed anyway in the screening procedure. Maybe it will be only focused on the administrative procedures, which would finally end up in the doing okay. But and also I totally agree with your point that the pushbacks are not happening at the regular checkpoints. They are happening in the green border, green zone, where we have no actually official presence of the monitors. Or, for instance, speaking about the Frontex, when we addressed the issue with the Frontex representatives, they said, okay, we are present. I'm speaking now about the land borders. We are present at the official checkpoints, but we are not present at on other spots. So they are not able to confirm or to monitor what could be happening there. Of course, I would like to recall also the number of the cases from the court. Coming back to some points which have been mentioned by the previous speaker, by Mr. Nielsen, concerning the independence of the monitoring bodies. I fully subscribe to that, and I offer also our assistance together with the United Nations, together with the Office of the High Commissioner for Human Rights. We can look at the Paris principles and also the expertise and normative work which has been done within the Council of Europe to check the independence of the future national monitoring bodies. Also, yes, we have the problem with the impunity. Definitely, as Mr. Nilsson said, and also Tinka Strik, that sometimes it's word against word. It's for us more easy to see, to verify, or to make the scrutiny of the laws or some standards, but not the factual events. And then I would like to again underline what the work what is done by forensic architecture and Bellingcat and those NGOs who are very important in revealing these facts and providing also evidence for not only for journalists but also for the monitors. The courts, it's a long shot. We need monitors. We need effective monitors on the place, because okay, we can go to court for interim measures, but the experience is that the court, for instance, in Strasbourg, is not very much eager to grant interim measures in the pushbacks incidents. On refoulement, yes, but I haven't seen much on pushbacks. There are also cases concerning pushbacks pending before the court, and we will see how also the judgment what will come on that. This is all what I wanted to say, and of course I'm ready for Q&A segment. Thank you very much.
Thank you very much, Mr. Stefanik, for these reflections. And this will bring us now to our final Q&A of today, and I would like to open it with comments by Dr. Hirsch-Zimbinska, who is Principal Advisor on Charter Compliance at the Office of the EU Ombudsman, and who will be shedding light on the Office's latest work on pushbacks, as well as reflections on the proposals in the new pact. Dr. Hirsch-Simbinska, the floor is yours.
Thank you very much. Thank you very much, Stephanie. Thank you very much to organizers of this very interesting exchange. And I heard all of that with a lot of attention. I would like just to say a few things. We have very limited time, so just actually 3 points concerning border monitoring mechanism and the new screening regulation, but not only. And then a few words about the most recent investigation of the European Ombudsman concerning pushbacks at Croatia and the Commission's response to it. So first about the monitoring mechanism. I mean, I was happy to hear when Thomas said, yes, we should reinvent the wheel. And when we read the proposal of the Commission, Article 7 specifically, of the monitoring and the borders, when the Commission requests member states to investigate, to adopt provisions to investigate allegations on the respect for fundamental rights in relation to screenings, our first thought was, but we have already ombudsmen who may do this job or who are already doing this. And then the regulation proposal distinguished between dealing with complaints about violation of fundamental rights in the screening process and the monitoring of fundamental rights compliance. But the ombudsman may do already both things. And finally, we have in the proposal these main features of the monitoring and the border screening procedure. It's excellent, but that the monitoring should be effective, quick, independent, etc. But this is also the feature of the ombudsman. The ombudsman procedures are flexible, quick, effective. And of course, the ombudsman are independent, should be independent and are independent. If not, they are not ombudsman. So all of that made us thinking, I mean, that where the ombudsman exists with the mandate to protect fundamental rights, he or she should be assigned tasks of monitoring the compliance of the screening procedure of the borders as regards the national actors taking part in it. And it seems that it would be beneficial for the protection of rights that the ombudsman investigate allegations of non-compliance with fundamental rights and provide for the monitoring. And they are doing this already. As you know, there are national ombudsman everywhere in the European Union except Germany and Italy. Many ombudsmen monitor compliance and national human rights institutions. Some are national preventive mechanisms under OPCAT, in fact quite a lot, 18 I think in the member states, or they act as monitors of forced returns under the Return Directive. The national ombudsman ensure protection by dealing with complaints, they undertake ex officio investigations, produce recommendations, reports, they go to the borders. Already they are dealing with complaints about denials of rights to seek asylum, pushbacks, non-compliance with refugee laws, etc. And of course, they ensure the right to good administration in response to allegations about the lack of individual assessment of each case or collective expulsion. Many scrutinize the border police and they check how the police effectively investigate complaints themselves, or how the police ensures safety for all persons working in the field. And here really, for all NGOs involved in this is really fantastic, and it's extremely important that your work is also protected. Finally, the ombudsman, by definition, as I said, are independent. But here, independence is one point important. The ombudsman must have resources to carry out the mandate. And I was happy to hear what Josephine said, that the monitoring should have funds, maybe funds coming from European money. And I remember when once I talked with the Polish ombudsman, whose situation is difficult, as you know, in Poland. And when they became an equality body, they were very happy to be an equality body, but they told me, yes, but we don't have money. We will do what we can, but with a new task should come money. So certainly this would help a lot of ombudsmen in all countries, but specifically, I would say the countries like my own, to have funds, and that it's recognized the new tasks and the money comes together. Then the second point, so the ombudsman, national ombudsman, if they take these duties, of course it could be somebody else, but if the ombudsman do this, we could ensure in our community, I would say, of ombudsmen, the full accountability of national, but also for European actors, of course not at the level of the ombudsman, because the European ombudsman and national ombudsman, we are all together joined in the European network of ombudsman. And we chair this, European ombudsman chairs this network. And this community may altogether ensure the full protection of rights, the European ombudsman being in charge of complaints against the European administration, and national ombudsman in charge of complaints against national administrations. And we have an example in the screening, this pre-entry screening procedure. We have, of course, national actors, but also Frontex, also EASO. And the European Ombudsman had already investigated, and still investigated in new investigations, for instance, Frontex or EASO. And if national ombudsman, our counterparts, do the job as regards national actors, and we, European Ombudsman, we scrutinize what the European actors do, then I think we will have the full cycle, we will close the full cycle of the protection, monitoring, and promotion of fundamental rights. And now I come to the third point to show what the European Ombudsman in fact already did. I mean, I will not speak about our past Frontex investigation, or I will not speak about our ongoing investigations concerning complaints mechanisms. I'm very happy to hear what Tineke said. In fact, it was her idea that we could go into that again, because we investigated this already once. We advocated that complaints mechanisms should exist. So I will not speak about this, but I will speak about an investigation which we opened a few days ago, following the Amnesty International complaint about the Commission's administrative diligence in relation to the European money paid to Croatia to manage European borders and set up fundamental rights monitoring. As we know, the emergency financial assistance, so-called EMAS, was contingent on the setting up of a monitoring mechanism able to ensure that all measures applied at the European Union external borders are proportionate and are in full compliance with fundamental rights and European Union laws. We know what happened. We discussed this today, what is happening still. And we, the European Ombudsman, we wanted just the first step in the inquiry to put to the Commission several questions to clarify the situation, because many things look very strange. We wanted to know from the Commission what, in general, does the concept of monitoring mechanism entail under European Union emergency finding. Our broad question was how the Commission ensures that the Croatian authorities respect fundamental rights in the context of border management operation financed by European Union funds. We wanted to know what is the knowledge of the Commission about this monitoring on the basis of Croatian reports, possibly on the basis of their own fact-finding missions, what the Commission did to verify the situation, with whom they talked, etc. And also we put to the Commission the question, could it consider recovering funds if there is evidence that Croatia didn't comply with the conditions of the project? What administrative processes the Commission has at its disposal to tackle such situations? And the investigation is still ongoing. And here I would like to come back to my earlier point that we could close the cycle of accountability somehow, because here we also, in this investigation, we turned it to the Croatian Ombudsman. We asked it for her input, and we could foresee an investigation in parallel, in a sense that Croatian Ombudsman, she already investigated this, but she could maybe shape it a bit differently, and she would go into to check, to scrutinize the national actors, and then we'll hear from the Commission what the Commission would be ready to do to remedy the situation. As I said, the investigation is still ongoing, so I cannot tell more. We are waiting for the reply from the Commission, and Emilio and I will decide the next step afterwards. Thank you so much. Thank you so much again, and extremely interesting contribution of all participants. Thank you.
Thank you very much, Dr. Hirsch-Zimbinska. I believe we have one more very quick comment from Christina Bavia at Forensic Architecture. We have about 30 seconds for that, if you would like to jump in now.
Yes, I mean, it's a really quick remark, but just because we haven't mentioned it enough in this panel, although it was a beautifully kind of composed panel, but essentially we have not remarked enough on the fact that there is, that the border mechanisms are operating with a racist agenda, And that is evidenced both through the case that I mentioned of Fadi Al Jazem, who was a Syrian person, but also was was holding an asylum registration in Germany. But also we've seen this very much in Melilla, and of course in many other borders. And my question is mainly to ask what mechanisms are there and what kind of work is done towards investigating the discriminating nature of the EU borders. Thank you.
Thank you, Christina. I believe we won't have time to answer the question in this session, but perhaps this is a good question for us to end the session on and to look into in our work going forward. It looks like we don't have any more time for questions now, unfortunately, but we would like to thank all the speakers and all the attendees for joining us today and for sharing your valuable insights with us. And we hope that today's discussion will facilitate ongoing exchanges and initiatives between stakeholders across Europe with the aim of putting an end to pushbacks and other rights violations at European borders. As mentioned, you will shortly receive a recording as well as key resources mentioned during today's discussion. So thank you very much, everyone, and all the best.
Thank you.
Thanks a lot for this event. It's very interesting. Bye-bye.